people aren't really choosing to plead guilty because it's what they want. They're choosing to plead guilty because there's a lot of external pressure, which is really dictating that choice for them. That the lack of judicial oversight really fuels this whole system, because people are almost acting in an unconstrained way, or they're only constrained by their own ethical guidelines that nobody is really policing. Autonomy. If people want to plead guilty, they should be able to. It's actually quite patronizing. It's like an infringement on freedom in its own way to say, no, you're not allowed to plead guilty. You can't get the advantage of that even though you want it. Well, one thing that people often think is that guilty pleas are admissions which are made by guilty people. And I know what we discussed last time is actually there's a lot of reasons why innocent people would potentially choose to plead guilty. And what the further work looking at this, what I've been thinking about recently is actually what do we mean when we say that innocent people are choosing to plead guilty? Some people will say that actually it's a good thing that innocent people can plead guilty because they might just not want to go to trial. It's giving them a choice. It's giving them freedom if this is how they want to resolve the accusations made against them. Equally, a lot of people don't feel the sympathy with someone who's pleaded guilty when innocent that they might feel with someone who's convicted by a jury when they're innocent, because there's this idea that the person has chosen to be convicted. They've chosen to handle the accusation against them in that way. But when you look at these cases, there's a real issue with whether there is real choice, whether people have really chosen to plead guilty, or whether they're essentially coerced, left with no real choice because of kind of external circumstances dictating that choice for them. And that's really important, because if we're convicting people when their guilt hasn't been proved, we have to convict them on the basis of choice. So that choice really needs to be real, rather than something that we kind of pretend is there because there's some kind of illusion that they've made a decision.
And one of the points you make, which is interesting, is that if you do plead guilty, it's actually harder to appeal than if you've had a trial and then can appeal against the outcome of that. So you are committing yourself in a big way by pleading guilty.
Exactly. And that's based on this assumption, again, that partly your plea itself is strong evidence of your guilt, which really in a lot of ways it isn't. And then partly on the basis that you're making a choice. And if you choose to give up your right to a trial, you can't then choose to have a trial through using the appeals system. So on the surface, it all kind of looks like it makes sense until you get down to the fact that actually people aren't really choosing to plead guilty because it's what they want. They're choosing to plead guilty because there's a lot of external pressure, which is really dictating that choice for them in some cases.
And then just going through what those pressures are, because I think it's worth just summarizing the kinds of pressures people are under. Some of it's the state itself, isn't it? Or the prosecutor, which isn't always the state.
Yes, exactly. And I think that's one of the really problematic things when we're thinking about choice in this area, is that the state, the prosecutor, they're setting the boundaries of the decision, and they're also the ones that benefit when the decision is made a certain way, in the sense that we want increased efficiency in the justice system. We want things to be handled quickly. We want things to be handled cheaply. So the state, the prosecutor benefit quite significantly when people do plead guilty, and they're the ones who get to set the parameters of the choice that people are making. But they, in terms of the specific ways that people might feel pressure, an obvious one related to the prosecutor is through charging decisions. And they're dictated based on kind of prosecutorial guidelines. And it's kind of an unknown question how that power is exercised. But essentially, prosecutors can say, if you plead guilty, we won't pursue more serious or more charges against you. So the post office cases provide an example of this. a lot of the defendants in those cases were told, if you plead guilty to false accounting, we'll drop the theft charge against you, or we'll drop the fraud charge against you.
That's a particularly good example because, as it turns out, that seems to have been driven by malice or maybe pragmatism. That is, we'll threaten you with a theft charge, but there wasn't any evidence in many cases of theft. They did anyway because they wanted to get a guilty plea, just to manipulate the naive defendant, which is it? Defendant. Silly me.
Potentially, yes. And I think there's big issues that we're still kind of looking into about how were the charging decisions made in those cases. Of course, a lot of them were private prosecutors, so the practice is slightly different. The regulation is slightly different from what it looks like in the Crown Prosecution Service. But definitely there's a lot of power there. And in those cases and in other cases, there's not enough evidence to substantiate the more serious charge, which actually means it should never have been brought. Now, the prosecutorial guidelines, the CPS guidelines say you can never bring a more serious charge, only to try to get a plea to a lesser charge. But the issue is who's regulating this, right? Who is looking and saying, oh no, there's no evidence for the more serious charge, particularly when some of these decisions are made kind of pre-disclosure, pre a lot of the evidence being aired. Yeah, it is something that I think is really important. And one of the things that I've tried to argue for with guilty pleas is this idea of giving people knowledge of the evidence against them so they can make informed decisions. The worst thing is someone's pleading guilty when they're innocent because they think there's a huge body of evidence against them and they're going to lose at trial. Yeah. And actually, like, there's no at all, it's not there. And I think that happens. And I think it particularly happens with kids, and particularly when the defendants are reliant on legal aid or have limited financial means before expert opinions and things like this have been explored. So really, I think it's quite difficult to police that regulation that says you can't bring a more serious charge if it's not sufficiently substantiated.
And we wouldn't really know anything about what judges do in relation to those kind of negotiations, if they do take an interest or if they simply really are so wanting the cases to be finished, to go along with this idea that you should get on with the cases. We don't want to spend a lot of time on them. We don't want to spend a lot of money on them. I suppose it doesn't invite the judge to get interested in what's really going on behind the scenes either.
I think that's it. And I don't know a huge amount about judicial decision making in this area. I do know that judges tend to adopt a very hands-off approach, and that's kind of what's asked of them. Judges aren't asked to conduct this thorough inquiry into why people are pleading guilty. In the US context, this was one of the things which John Bloom and I noted in what was my first article on guilty pleas almost 10 years ago. That the lack of judicial oversight really fuels this whole system, because people are almost acting in an unconstrained way, or they're only constrained by their own ethical guidelines that nobody is really policing. And that means that what goes on is somewhat, I think we called it an unregulated industry. And I think that's definitely what we have in England and Wales with respect to overcharging. When I first came here from the United States, came back here from the United States, a lot of people said to me, we don't have charge reductions here, right? Because people's perception is that the only discount you can get for pleading guilty is the sentence discount applied by the judge in the sentencing guidelines. And because that only deals with sentence, people will say, no, we don't do charge discounts. That's an American thing. That wouldn't happen here. And where charge discounts are offered, they're modest. But as soon as I started researching this, when I started asking lawyers, what are the kind of discounts you see in practice, they're actually quite significant. But they're a little less obviously significant than how they look in the United States. So in the United States, a lawyer might say to you, my client was charged with rape, and they were allowed to plead guilty to, a minor assault. And so you see that kind of crazy discrepancy. Here, you might see something more like they were accused of murder and they pleaded guilty to manslaughter. And that sounds relatively modest, relatively reasonable. But when you look at the sentence discrepancy, it can be something like 3 years for the manslaughter charge and then something like 15, for the murder. It's actually a huge difference in practice, even though it sounds a little more reasonable.
There are a lot of other factors going on inside the head of the person who's in the dock as well. Not just the threats that might be hanging over them in terms of sentencing.
Yes, and it's particularly an issue when people are kind of held in pretrial detention, awaiting trial. They'll often have the opportunity to get out sooner if they plead guilty, whereas they might have to sit in these detention facilities for an extra period if they don't. This brings up kind of all sorts of issues, particularly for single parents, for people with precarious employment, and, in reality, for the rest of us who also probably wouldn't want to spend months sitting in these facilities either. So there's a lot of pressure which actually isn't related to the sentence at all. It's just like, I need to get this done. I want to get this resolved. I need to get out, and pleading guilty is the way to do that.
And the other issue you draw attention to is cost, that if you try to defend yourself, that can be very expensive.
Yes, exactly. And I obviously won't go into the legal aid issues. I'm sure you've probably had people who know more about legal aid than me talking about those, but people who are on relatively low salaries won't be getting support, won't be getting full support. So they can't afford to go to a full trial, or they don't feel that they can. The other issue relating to that is that people can't necessarily afford to retain experts. So, for example, when you look at the post office cases, you see that a lot of people are saying, well, my lawyer told me we can't afford to contest this. Like, we can't retain experts who can challenge the experts of the post office. So we're going to lose, right?
Yes.
And you're going to spend a lot of money, and then we're going to lose because we don't have the money for the experts. So plead guilty, get it over with, avoid jail. And these things kind of all come together. And it's a huge amount of pressure. And I think the sheer number of people who plead guilty in those post office cases just shows you that it's not sensible to say, oh no, you should have gone to trial, because the pressures influence everyone.
And then the question, of course, is what can you do about this? Because, as you say, some of the issues are kind of baked into the prosecution process, and many of them just sit on the backs of the people who appear in court as part of their life circumstances, which, it's a whole range of different kinds of problems which one might need to influence in order to make any difference to this.
Yeah, I think that's true. And in our paper, we've raised kind of a lot of different solutions. And I think it's hard at the moment because the funding isn't necessarily there in the criminal justice system to do all of these things, right? And so we've tried to suggest like a range of things that can help. And then as the funding's there, kind of more of them can be done. One thing is actually educating people themselves to feel a little bit more empowered with their legal rights where they can. Of course, in some cases, the system is such that isn't going to help, but it's something. One thing that we've really tried to emphasize is the responsibility of the state to put people in a position where their choice is autonomous. So making sure, monitoring the incentives that they're facing and making sure they're not facing coercive incentives.
We had a very, sorry to butt in again, but we had a very interesting talk with Nathan, the ex-policeman, whose comment was never plead guilty because so many things go wrong before you ever get to court. And there's but he was dealing with experienced criminals, I think, on the whole, who kind of knew where they stood.
Sit it out. I mean, career criminals who
prepared to sit it out, who knew that witnesses sometimes fail to turn up at court, who knew that sometimes the evidence doesn't stand up, and that the threats of prosecution may evaporate for various reasons. But I think he was dealing with different kinds of people rather than the ones you're most concerned about, who are either chaotic in their lives anyway, and therefore, struggling to cope, and adding the problem of having to be autonomous and make these masterful decisions about their future is just not a thing which they would normally hope to do. You're dealing with people whose lives are usually in a mess, I think, for lots of reasons, not just the criminal offence that they've been charged with.
Yeah, definitely some of the time. But I guess one of the things that I tried to emphasize as well is it kind of could happen to anyone.
Definitely.
And that's a worry for everyone. Yeah.
Quite well, because these aren't people who have really been involved in criminal activity. They aren't people, who are typically pulled into the justice system. So it really could happen to any of us. Obviously, you have to be unlucky. But that's one of the big things, which I've been saying in my work, is that we have to consider these incentives, particularly where they make people plead guilty, where they are very unlikely to have been found guilty at trial. You can justify it a lot more where you're saying, oh, they pleaded guilty, but they were most likely to be found guilty at trial anyway, and they got an advantage. But when you see people who aren't even really looking at the probability of conviction at trial, don't even really care about that, and they're saying, no, I need to plead guilty because, either I can't get to trial, I can't afford to get to trial, or I can't just take the small risk of trial happening and an adverse outcome happening at trial. Because then it's really detached from this idea of, will I be found guilty? And it becomes a different kind of decision, which is even further detached from factual guilt or innocence.
I think the other problem for those people as well, Rebecca, is, as we know from the people that we've spoken to, and we know you've spoken to some of the post office people, they have no understanding of the outcome in terms of their mental health, their physical health, what might that plea lead to, the loss of money, the loss of property, the loss of your reputation. And so many of them are really ill, really damaged. And I don't think nobody ever explained to them anything like the consequences, because, we have one wonderful example, a terrible example, but it shows how many people have been destroyed by the system, and we're responsible for that. That the state and the post office is responsible for that, and nobody's even discussed that as a possibility. I don't think people have realized the awfulness of the outcomes and consequences either.
Yeah, and I think it is a shame, particularly when people have pleaded guilty, because you do end up placing some portion of the blame on them, which, I really try and make sure that people don't do that in kind of my teaching and my outreach. Like, just make sure someone who's pleaded guilty, actually, it's just as much of a miscarriage of justice as it is for people who've gone to jury trial. It has just as much of a detrimental effect on their mental health. And it's not that they've chosen it, because actually that outcome is fine for them and it's okay and they're willing to deal with it. It's because they didn't have a choice. And the thing that I think is really interesting about the post office cases, and which is really great, the attention which those people are kind of making sure that they get for their cases, is that just because you don't sit in prison for 20 years doesn't mean that this hasn't had a really dreadful impact on your life. And one thing that I find interesting about the post office cases is even the people who didn't end up convicted actually are in a pretty horrible position and have gone through a lot. And one thing that people may not have realized when they pleaded guilty is how the press would report it. And there's a lot of interesting questions around that. You look back now at the press coverage following their guilty pleas, and it will say things like, disgraced postmaster admits stealing from the community. Yeah. And people are going, they haven't actually admitted it. They pleaded guilty. We're kind of incorrectly equating the plea with guilt. And then they're getting people like spitting at them in the street because they presume that because they said they were pleading guilty, they did it. And I think that is a big problem.
Let's say somebody does take if somebody does take a view that the guilty plea is not justified, and there may be several people aware of that. It may be the defense solicitor, it may be the defense barrister, but it may be a judge even, if they do take some kind of view of things. What do you then say to the person involved? Say, well, actually, we don't accept this this guilty plea, this kind of quick solution that you've opted for. We think you should go to trial. The consequence may be they have to spend longer in custody. They then have to fund their trial, which they may not be funding for. They then have to put up with all the delays and stress that involves. And somebody has decided that that's what they must do because they don't accept their guilty plea. Or they, it's a very difficult scene to imagine playing out, really.
Yeah, I think I told you before, one of the first cases I was kind of aware of was one that John Bloom was working on at Cornell, a guy called Edward Lee Elmore. And it raised a lot of issues that John kind of shared with me about, like, when would a good lawyer actually advise their client that they should plead guilty? So I think related to your question, there's this idea that actually in the current system, it is the right thing for innocent people to do, to plead guilty under certain conditions. And that's really unfortunate, right? So we need to change the fact that that's the case. And then the second thing, which I think is more directly responsive to your question, is this idea of like autonomy. If people want to plead guilty, they should be able to. It's actually quite patronizing. It's like an infringement on freedom in its own way to say, no, you're not allowed to plead guilty. You can't get the advantage of that even though you want it, because, we don't think you have the right reasons. And quite possibly people in that situation will turn around and they'll tell you the right reasons, right? And then what are you going to do about that? And you see it in the United States where there's kind of different guilty pleas. And, you can either plead guilty or you can plead guilty and maintain your innocence, or you can plead guilty and make it clear that you're just not contesting the charge. And the upshot of a lot of it for me is that people are kind of willing to say what they need to say to be able to plead guilty, where the case is that pleading guilty is the best thing for them to do. And it's the logical thing for them to do. So I definitely don't think that defense lawyers should be turning around and telling people, in my opinion, you can't plead guilty, you shouldn't plead guilty if they want to. I do think defense lawyers have a role in kind of empowering people to feel that they can contest charges if they want to. But again, that's very hard where defense lawyers aren't equipped with the resources that they need to give them a fair shot in the trial. And so that's why it's kind of tied up in these kind of systemic issues in the system. In terms of what the judge would do, that's particularly hard. Because, if a judge throws back a guilty plea, what are they saying? Are they saying you have to go to trial? And what if you can't afford to go to trial? And I think for me, the judicial oversight would be more about saying, why are you pleading guilty? And if the person says, well, I don't feel like I have a choice because they've threatened me with theft, the judge would then go back and say, like, well, is that theft charge actually substantiated? And if it's not, you could go back to the person and say, well, the theft charge against you is dropped anyway. Would you still like to plead guilty? Or something like that. Changing the judiciary is empowered to kind of change the choice that the defendant has to make, to give them a choice, rather than to tell them, like, no, sorry, we know there's advantages to plea, but you have to go to trial.
Do you get the impression that the American society of Americans, they understand more what's actually happening with the criminal justice system? Because I get the sense here that masses of people they're not interested for a start because it never affects them. But then when they read about it, they actually believe these press reports. They believe that if, people only plead guilty if they're guilty. They believe that there aren't many innocent people in prison.
Yeah, I definitely think that's true. I do think the US was almost in the same position as us maybe 10 years ago, and this stuff's kind of got increasing traction recently, which is good. A lot of research has been being done. But I do think more needs to be done here to raise awareness of the issue. I always feel uncomfortable when people equate guilty pleas to admissions. And I think more needs to be done to kind of get away from that language. The problem is, if we don't genuinely see it as an admission, it's very unsatisfying for the public. So if the press reports, in a murder, the defendant has pleaded guilty, but they may not have done it, like, that's probably wouldn't occur in a murder. So it's not the best example, but you see the point that it's not particularly satisfying because people want to know who did it. They want justice. And if we don't use the word admission, then the question is, well, they pleaded guilty, but did they do it, right? So it's this systemic issue, which is that our justice system isn't doing necessarily what we want it to do in this probably, reasonable minority of cases. And when we report that, it's going to cause a lot of dissatisfaction with the system. And so I think people are reluctant to do that because we want to see that the system's working. We want to believe we're getting justice in these cases.
And the state has to promote the legitimacy of the justice system. I mean, it's not a good look to start saying, well, yes, we have this system which, in fact, quite systematically pushes people to plead guilty when they may not be, or they're certainly not guilty of that particular offence. And to some extent, justice is a theatre. That is, most offences aren't prosecuted. Most people who commit offences don't get caught. But there's a warning goes out because we know about trials and we hear about the outcomes. And so that pressurizes people to keep on the straight and narrow because they might get caught. And the likelihood of committing an offence probably relates most closely to your expectation of getting caught or not. And so if the judicial system is undermined, then that undermines the theatre element of the whole judicial system as well. So there's a huge kind of incentive to pretend that it's all going very well. Even if the public are happy to be fooled, it's still not a good, it's not a good thing for the state to admit to.
There's a really interesting article by Richard Nobles and David Schiff from Queen Mary, and they say, like, what the public think that a conviction in the criminal justice system means that someone did it, but actually all that a conviction in the criminal justice system means is that 12 people think that they did it, or that they, are willing to say that they did it in court. And for the sense of finality that the system needs to keep operating, the legal system has to treat guilt as what 12 people think or what someone says. That, they can't treat it as what someone actually did, because how do we determine what they actually did? We can't keep revisiting it. We need finality, right? These kind of philosophical questions. So it's really interesting because there is this huge divide between what people think a guilty verdict is and what a guilty verdict actually is. And we hope that in the majority of cases they overlap quite nicely.
This is a tremendous argument there, Rebecca, because if you can kind of question 12 people's opinion of that sort and just put it in context of that sort, what about the 50,000 or million or so Twitter votes that you might get based on perhaps very little evidence, but there's lots of people who think it. So and a lot of the public are behaving as if people are guilty simply because there's been a kind of outcry against them, and seem quite happy with that as a way in which society could function.
Yeah, I have a colleague called Rachel Jimson at Exeter who does really good work on this, like social media and the legal system, which is so interesting. And she's talked a lot about how we've kind of shifted from, innocent until proven guilty. We've made kind of inroads in this kind of, in the defendant's rights, which we've previously had, because we are kind of judging people before trial. And I think that that's really important. And of course, it often does influence juries as well, even though it shouldn't. There's a lot of research on kind of pretrial publicity in juries. But yeah, I mean, the jury, even more so Twitter, like what they think isn't necessarily right. It's not necessarily foolproof by a long shot. And I see this every day when I'm looking through the cases in this miscarriages of justice registry, right? Even if you give people all of the evidence, they might make the wrong decisions. But actually, people are also just so vulnerable to being given a subset of evidence that doesn't represent the truth. And they're going to make the wrong decisions then through no fault of their own at all. So
it's a fascinating area, isn't it?
Yes.
Are you finding there's some attention being paid to this? For example, in the Ministry of Justice or amongst judiciary, are people wrestling with this at all, or are they trying to avoid thinking about it?
I mean, I think everyone wants criminal convictions to more accurately reflect, the truth of what's actually happened. And definitely, policymakers, MPs, particularly there's an APPG on miscarriages of justice who are really engaged with like how we can improve what you might call like factual accuracy in convictions. But it's just been on the back burner, hasn't it? And obviously that's no help to the people going through it. The big question, I think, is this balancing of priorities between defendant rights and the rights of complainants, and of course the rights of like victims, real victims. And you see it in cases, sexual assault cases are a really good example, because when it comes down to what one person said versus what another person said, we know that sexual assault is much more common than false accusations are. And it's where do you set that boundary, right? Like how many guilty people are we willing to let go free to make sure that no innocent person is ever convicted? And I think we had that famous mantra, right? Is it like better to let however many guilty people go free than to convict one innocent person? And I actually think maybe society's attitude towards that is changing a bit. And I'm not saying that I think that it should be.
In which direction, though?
Well, there was an article recently that showed that people care. They care about both wrongful convictions and wrongful acquittals, but they care about them equally. So this research suggests that people aren't saying, well, a wrongful conviction is loads better than failing to convict a guilty person. They're saying these are both problems, these are both errors, and we need to care equally about the two of them. And I think that comes from the systematic kind of failures to prosecute things like rape, where people are saying, actually, it is awful to find guilty people not guilty. And so we care about both problems now more than we used to.
What do you think the ratio should be of guilty people who walk free versus innocent people? Where do you think the public sits? It can't be 50-50, can it? I mean, that's... I don't... we might all care 50-50, but might not actually in practice apply 50-50.
I mean, I think probably what the public, if you take it seriously that people care 50-50, and let's say they do, the public are going to want maximum accuracy, and kind of it doesn't exactly matter like whether errors occur at one end or the other end. They just want you to get as many cases right as possible. Actually, I mean, the reality of it is that if the police are doing a good job, the best way to do that might be to convict everyone who comes into court, right? Because we presume there's a strong case against them. And that's not what I would ever suggest.
That's the Chinese method, or Japanese.
I would never suggest doing that. And so I think that's why it's kind of important for people to engage with these issues a bit and think about this prioritization of wrongful conviction versus wrongful acquittal. But it's interesting because I couldn't even give you an answer. Obviously, people just want no guilty people to get away with it and no innocent people to be convicted.
And off we go down the yellow brick road, hoping that it'll all be just fine at the end.
I suppose, doesn't it show, though, how much we need legal aid to be available? So, on the one hand, people will say that, but I expect on the other hand, they'll say, well, we don't want to spend, huge amounts of money on legal aid, but that's the only way. I mean, a system can only work well if actually people are prosecuted appropriately and defended well. There's no shortcut, is there?
If the system works well too. So one of the reasons I've been thinking about this a lot recently is I'm writing a book on juries. And it's a really interesting thing to think about. How are juries functioning? Are they functioning in a way which promotes accuracy, right? Or do they promote kind of other types of decisions influenced by different things? So kind of conceptualizing the jury as like a machine, right? It's a machine made up of people, but it's this, decision-making body. And is it functioning in a way that maximizes accuracy? Or is there more that we can do? And I think evidence-based policy is really important here. Learning from science, scientific disciplines, experimental method, data science, and to try and create a criminal justice system which functions the way that we want it to function, rather than having this kind of dissonance where we tell ourselves it functions how we want it to, but actually that's a bit of a myth, and it's off there doing something else, right? With innocent people saying they didn't do things, and guilty people not being convicted.